the court. My name is Martha Karoa, Senior Counsel, leading the defense, but I do notice that the prosecution is not here yet, and also our clients have not been brought. And I'm requesting the court that I withhold the introductions until that, at least the accused are. And usually the prosecution bench is empty. But we are ready to proceed nevertheless. What we have before you is an application by the prosecution dated and we'd be happy to seek its dismissal. It's their application dated application 101 of 2026. Dated the 2nd day of March 2026. And generally, it's an application for concealment of identities and non-disclosure of any material that is likely to reveal identities of 6 prosecution witnesses before their testimonies in court. All the 6 witnesses, which we oppose and which would urge you to dismiss for want of prosecution. Please. Yes, the replies were filed yesterday, 30th of March. We have a replying affidavit sworn by A1 Dr. Kizza Besigye and A2. So there are 2 affidavits, both sworn yesterday by A1 and A2. I don't know whether in the circumstances you would like us to add anything else, because the application is not prosecuted. If any of my colleagues wishes to add something, I give way.
Just for the record, the matter was fixed by consent before court here. The court directed the prosecution to serve, and we come back to them. They have chosen not to appear. Yes, my lord. The matter was fixed by consent before you in open court here. And directions were made that the prosecution should serve the accused persons on that day, which they did, from the cells down here, and witnessed the service of the application. The court directed, we come back here today. On their own volition, the prosecution of state have opted or elected not to appear, meaning they have abandoned the application. And the only logical thing to do is to strike it out. My Lord, it's a criminal session which is ongoing. My Lord, the application was coming up before you for further management. And management presupposes disposal of the same. Whether it is for mention, whether it is for hearing, it's for further management before court for a decision to be made. And the state is urged to appear. They have no choice. It's not at their liberty whether to turn up or not. So once they fail to turn up, the implication is that they have lost interest in the matter. That's what it means. Even if it were if my Lord, the management would be to fix them, they are not here. They have elected not to come. So the hands of court are tied now in their absence. And finally, my Lord, the court cannot act at the whims of the prosecution. Their penal sanction, their sanctions from non-appearance by a party. More so, the prosecution. If they don't turn up, it is always there is always a penalty. No explanation, nothing, and the accused persons are incarcerated. They are on remand. Their liberties are curtailed. That is a serious matter, my Lord.
I agree with counsel for the respondents, accused persons, that when this matter came up on 12th March, both parties were present in court. It is also true that on that day, court gave directions to both parties, and court adjourned this matter for today for mention on whether the directions given by disciplinary court were met. It is unfortunate and surprising that the applicant of this application for the prosecution, they are nowhere to be seen. True, we also with the respondents team that this matter was fixed for 11 and did by 11 the prison's officers and the respondents were not in court. As I write this ruling, it's now 30 minutes past midday, more than 1.5 hours late, and the prosecution is nowhere to be seen. It is also true that the applicants or the prosecution filed this matter on their own motion, but they are nowhere to be seen. I have perused this court record, however, and I noted that indeed, as submitted, when this matter came on 12th March, it was adjourned today for mention. Although the prosecution or the applicant are not here, it is my view, and for the interest of justice, and by the nature of this case, I am arrived to the nature and circumstances of this case and the history. I will give this application last adjournment for the interest of justice. Giving it last adjournment, and this last adjournment of this matter, of which court will take action, is next week on the 7th April at 11. And so forth.
My Lord, with all due respect, yeah, we just wanted to register concerns here, my Lord. One, my Lord, the prosecution which filed the application not being here, and in light of your ruling, my lord, that you are giving them a last chance, my lord, these are our concerns which we would like to have on record. One, my lord, that court has not been moved by anyone to have this matter adjourned. We would like to have this on record. They didn't write, at least to say they are not here for one reason or another, and no one is moving to court, my lord, for an adjournment. We want to be on record. Secondly, my lord, for us, our side, we are ready to proceed and we are constrained. Because, my lord, we have been unfairly accused of delaying this matter. We, the lawyers, and the accused persons, both in the court here and in the public domain, maligned, chastised, with that narrative that actually we are playing ping pong, delaying tactics. Now here we are, my lord, before you, ready to proceed, and the prosecution is nowhere to be seen. And my lord, time and again, we have asked you to reprimand them for their dilatory conduct. This is not the first time. It's not the first time they're exhibiting dilatory conduct. Even filing this application, my lord, was an afterthought when we are at the advanced stage of scheduling the matter for hearing. You had given directions for disclosure, which they never complied with. The first time they were supposed to close their disclosure was 21st January. Today is the 31st March. They are still documents they have not served. They have not closed the disclosure. And as we are grappling with the issue of disclosure, they jumped on an application to conceal witnesses. And my lord, you recall the proceedings of that Dr. of March. We had asked court to first pronounce itself on the issue of disclosure. And my lord, in your wisdom, you chose to first deal with the application. You said, no, let's first dispose of the application, then we go back to the main case. Now here we are, in the middle of a jungle, in the middle of a forest. We are all lost there. Court is in the middle of the forest. The other advocates were in the middle of the forest. Accused persons, all of us, we are lost in the middle of the forest, where we are dragged by the prosecution here, and they are nowhere to direct us. Where to go next? My lord, we take exception of this conduct, and the court should take this matter seriously. Stern measures should be made. I was concluding, my lord, that the accused persons have been incarcerated since the 16th of November 2024. since November 16, 2024, up to the present day. We have applied for bail 4 times, which has been declined. And the court has always listened to the state. Now I'm concluding. Yes, my lord, 4 times. The first one was before Justice Kamfatikani. It wasn't before.
To be fair.
Yeah, to be fair to you, my lord. The first application was not before.
4 times before me. You are not being fair.
Maybe what I should say in conclusion on that particular matter, my lord, including a mandatory bail, was denied.
I think that is the only application for bail.
No, my lord.
Yes. In this case, I have only handled one.
No, my lord. For the record, my lord, even when we
You have my rulings more than one.
yes,
One day.
yes, there is one where we asked my lord to terminate the to stay the proceedings and release the accused person. It's on record, my lord.
The one which was
Stay?
handled was stay.
Yes,
At least
it was an omnibus application. Stay and release.
Maybe now we say 2, but when we say 4,
There was also one before Justice Kamfatikani. And my lord,
okay.
the whole point is that
They
they have overstayed on remand. That is the whole point. At the instance of the state, who have always moved the court to deny the accused person's bail. Now they exhibit this kind of dilatory conduct, holding all of us at ransom. My lord, this time round, we ask you in the interest of justice, reprimand these people, reprimand them. Stern action must be taken. The right to liberty is next to the right to life under our chapter 4 of our constitution. The first, right to life. The second one, right to liberty. And it is, and my lord,
on those measures which you have in mind. Because last time you wanted to submit to it, you didn't allow it to submit to it.
my lord,
Before we go.
you are asking for? Yes. And to have it on record that we are not responsible for the delay of the prosecution of this matter. That the accused are not responsible for it, neither we the council. And the state should stop driving that narrative here and elsewhere that we are playing delaying tactics. Then reprimand follows.
Place this on a record court. For the record, Thomas Yatiko, Assistant Director of Public Prosecution.
Yes.
I am appearing this afternoon together with my colleague, Richard Munguka, Chief State Attorney.
It is very true.
My Lord, the prosecution humbly apologizes for the delay that it has caused to this court and to my colleagues who are present in court. This case was fixed for 11 a.m. today, and it is way past that time even after the prison came also after that time. We are surely apologize to this court and my colleagues. I think the last time this matter was in court, the court had given us timeline, and the court directed that the prosecution serve the accused persons, which we did serve the accused persons on that very day. And all the respondents were directed to file their reply by the 26th of March 2026. And my lord was not only at about it was not only until yesterday at night when we checked the witness that the respondents had filed the reply as opposed to the 26th of March 2026. And my lord, this matter was fixed to today for mention over the same. However, because since 26 we have been expectant, so we have been looking at the elections every single time, and it was not only at night that we discovered that these replies had been filed. My lord, we retaliate our prayers that we are sorry for coming late. And that this court please grant us directions in respect of the miscellaneous application that is presently before court. So I'm
My name is Martha Karua. From where we stand, it doesn't sound like an apology. After coming almost 2 hours late and not bothering at all to even send somebody to seek time from the court, they just assumed the court will wait for them. They are confident the court will not sanction them. They are now telling the court they are not even ready to proceed, even if the court won. It is true we filed our responses yesterday and we had already told the court that. But it's also obvious that our clients are not free. They are in custody. And I'm sure the court, both the court and the prosecution, are aware of the rigors of getting documents to persons in custody like themselves, getting them commissioned. We filed yesterday because that's when the process was complete of commissioning. But at least it was filed before coming to court and we were in court on time. Had the prosecution come to court on time, or at least one of them, because there are normally 3 counsels, at least one ought to have come to explain to the court that they need time, but not just to leave the court wondering what is happening. I will let my colleagues add to that, but I would urge the court to note that the prosecution is comfortable that they can do as they please in this court. They do not have to answer in terms of time. They can come their own time and offer some apology without even explaining why no message was sent to the court. Like we said before, we need equality of arms. We need not just equal treatment, but it must be seen that we are treated equally before the court and no party has an upper hand. It is the duty, your duty, my Lord, to make every party know that we are equal before this court and there is no favorite. And that when the court gives time, we all must obey. We did not, even though we filed yesterday, we have not delayed the court because we did do what was within our power after commissioning. And for us, if we were late even for a minute, we would at least send somebody to let the court know that we have difficulties. We would not assume that the court will wait for us for 2 hours. I don't know whether any of my colleagues would like to add.
Much obliged, my Lord. My Lord, by and now for the record. Specifically, my Lord, I would want to bring into the attention of this court that the learned assistant DPP, Mr. Jadiko Thomas, in furtherance to the continuous abuse of this process, has just stated a lie to court that he has filed an affidavit of rejoinder with an assumption that probably we, the lawyers, are not looking at the system. But, my Lord, I am looking at the system, and there is no affidavit in rejoinder filed by the state. My Lord, ordinarily, and I know that you will argue that the same has not yet been admitted. My Lord, if a document is filed on ICMIS, the same shows if it's pending admission or if it has been admitted. My Lord, that document does not reflect anywhere on the system, and we request court to take issue of the same, and even if they argued that they instructed the clerk to file the same, the position in Amama Mbabazi versus Yoweri Museveni and another, election petition number 1 of 2016, is that council takes responsibility of mistakes both in filing and after filing, and he does not shift that responsibility to the clerks of his office or his juniors. My Lord, we pray that court reprimands the prosecution for that conduct and stating a lie to court. But secondly, my Lord, the prayer is that the prosecution is struck off the record, because it is true and correct that prosecution came late and the record of the application had been already taken and representation was already stated. My Lord, further to the submissions of the learned assistant DPP, is that he now seeks court to review its ruling and give directions in that regard. My Lord, my submission is that the court is already functus official, and the rule binds this court. And maybe to update my learned friends of the prosecution, what we are discussing now are measures of reprimand and the date of the next appearance. And therefore, any allowance or entertaining the submissions of the state would be reviewing court's decision, which is an act that we submit that it's illegal, and court does not have those powers. And maybe lastly, since we were discussing measures of reprimand, I would want to suggest to this court that prosecution and their client, the state, should be reprimanded in ordering them to pay costs of the day. Because, my lord, as you are aware, the accused persons are heavily incurring costs to make sure that their case is prosecuted. Including but not limited to one of the advocates who is the leader of our team, senior counsel, Martha Karua, travels every day from Kenya to come to this court. Not to say that personally, some advocates on this bar travel to pick her from the airport, and all those are costs that court should not really take a blind eye to the same. And therefore, I reiterate the earlier submissions of my learned senior counsel Elias Ukwago, that the state should be reprimanded, and more suggestions on reprimand can come from my learned brothers on the defense side, but starting with costs of the day. Much obliged, my lord.
But the least this court can do is to condone a lie being told or raised by a person of that caliber. Assistant DPP telling a lie to this honorable court. It is something that is serious. The two are not connected. The appearance today at 11 and the filing of the affidavit in reply are not in any way concomitant. They are not connected at all. So their non-appearance today at 11 should not in any way be linked to the filing of the affidavit yesterday. They shouldn't. That's a blatant lie. I don't need to overemphasize this point, my lord, that if a litigant, the party to the proceedings, is served late, you don't elect to come to court late without reason, which is pedestrian in nature. You cannot. That simply because the accused persons filed the affidavit yesterday, they come to court late, or they choose not to come at all, and the court entertains that. It's the least one would expect from an assistant DPP. These are matters of life and death. We are talking about people's liberties. We are talking about the accused persons' lives. And you who is at large, you is at liberty to roam around, you are at liberty to tell court that we could not afford to come here because they filed the affidavit yesterday. Do you know the intricacies involved in having an affidavit commission? What Senior Counsel Martha Karua was explaining here, my lord? The rigors we go through to represent an accused person who is incarcerated. You prepare an affidavit, you go, you take it there. This is a 4-page document, rather a 6-page document. But it takes about 3 to 4 days or even a week for the authorities in Luzira to go through the same. I'll tell you, bring it. You'll come back another day. And then the Justice of Peace will have to take their time before they commission it. I wish we could be allowed to have our own commissioner we go with to Luzira, and we have the document commissioned by our commission. But it is the Justice of Peace over whom we have no control. I wish they considered to bail so that our accused persons are free and we handle matters from outside, from here. I wish they considered to bail. So, my lord, we pray that you roundly reject those blatant lies told with the contempt they deserve.
First of all, today was not a day for hearing. Today is a day for election. But it's not for coming day.
Yes.
It's not a justification, my lord. It's not a justification. Yes, it's not a justification. And my lord, it would be unfair for court to slap costs of prosecution. And my lord, it's good that court has been vindicated. Using as to why we came in late. We have been vindicated, my lord, it is on the system. It's also very unfair for my colleague Bayan to be now with due respect. You say that prosecution shouldn't be put on record. We therefore, my lord, reiterate our earlier submission. For the electives. This matter. Ruling. I have very carefully listened to both parties. I will now proceed to make the following remarks and findings. I am aware and alive to the fact that this honorable court, few minutes back, before the applicant stroke prosecution came into court, this honorable court had made a ruling to the effect that the respondent's counsel had made an application for a prayer that this application be dismissed for non-appearance of the prosecution which had filed this matter. Basing on the above prayer that the case be dismissed because of non-appearance of the prosecution, this honorable court made a ruling that for the interest of justice, this application is given last adjournment, and this court went ahead to make the last adjournment as of 7th of April. However, Counsel Kwago and Senior Counsel Mata requested to submit on the date which was not convenient to them, that is 7th of April, and Counsel Kwago still submitted requesting court to reprimand the prosecution because of their conduct in this matter. At this juncture, it was when the applicant, the prosecution, entered this honorable court. It was proper and in order for this honorable court to listen to the prosecution as to why they have come late. I will not reproduce their submissions, why they have come late, the same as the court record. I will not again reproduce all the submissions from both sides. However, I want to say at this point that this honorable court's hands are not tied. This honorable court cannot close its eyes and say people have come late and they retract the direction of this application. I listened to Counsel Triminawe, how he submitted that this court is factors of the issue. I don't agree or subscribe to that fact. And even if it is the point, this court's role of listening and making some other directions would be unfortunate if court says that it stands at time. However, I want to say that I agree with the counsel of Babel that this honorable court, true, now I am coming to the prayers even he made before. I agree that this court made directions on the issue of disclosure and directed the prosecution to make full disclosure. True, it was not done. At that point, I agree that this kind of practice is not proper or is not in order for parties not to follow the directions. I also listened carefully to submissions by the Council of Power Senior Council, and I agree with them that this matter was adjourned when the Constitution was in court. And we agreed that the matter would come for mention today at 11. Therefore, for the prosecution to come late, to be specific, the matter was at 11 and they come like a half past midday. My view, and where I agree with Council is what we call courtesy. The prosecution should have had a courtesy to send another prosecutor to inform court and other people that they will come late. In alternative, even a simple sin, the prosecution should have made a call, just a mere call to the defense team that they will come late. They had done that courtesy, wouldn't be in this lengthy submissions. So therefore, it's not proper, it's not in order for putting court at random, and the entire court to wait for more than an hour. At least I am aware that the prison authorities and the respondents who are accused persons, at least they came at midday. But for the prosecution not come to court when we are here from 11 to midday, from this midday to half past midday, such a conduct is not proper. I want also to take note, however, that when they came, they made an apology and it is on record. I will now turn to this application before this honorable court. After making my remarks and findings, let me turn to this application, and I will say, I don't say that my hands are tied on the other ruling I had made before, but I will proceed to make some directions in this particular application. Since the respondents have since filed the reply, although late, that was they were supposed to file by 26th, they didn't, but all the same they filed, as they said last month. So they said it's on record. Also, I have listened to IT has confirmed this one I was told, that the rejoinder is also in court record. Therefore, the proceedings in this application are done, accomplished. So, on the issue of costs still paid by Yoweri, I want to say that true, the prosecution came late. For that matter, I'm reluctant to give orders for costs of today as submitted by tomorrow. I will now proceed to give directions. I am aware this application is tying down the main case
which is session number 335 of 2020. Therefore, I want to conclude by saying that the proceedings are complete. I am now giving directions in this matter, but since I had heard counsel for the matter that sentence is not convenient, let me listen before I give directions and then they come on the issue of the day.
Most obliged, my Lord. Martha Karua for A1 and A2 together with my colleagues. I withdraw the objection to the 7th after consultations with my colleague. I will stand down whatever was happening on the 7th so that we have the matter heard at the earliest. Because all the other available dates are far off.
On 21st of April at 11, what will give the direction on how to proceed in this matter. Having said that in this, the same main section number 335 is that young information on that day pending disposal of this application.
Yeah. We cannot have this.
When it comes to the trial,